to take down the instructions because I will read them verbatim so she doesn't have to type them. We will have the full record. Does the state have an issue with that?
No, sir.
Does the defense have an issue with it?
No, sir.
I won't go off the script until we're finished and then she'll pick back up. I'm going to, so the parties know, reiterate the admonition relating to social media. I'm going to add to that, but it'll be afterwards and that'll be on the record.
So after he's done with his, might go to.
Stand for the jury.
Thank you, everyone. Please be seated. Let the record reflect the presence of the jury panel, the defendant and counsel. Ladies and gentlemen, good morning. We're here for our first day of trial. What we're going to do today is we're going to start out with the reading of the indictment. Sarah Lynn's going to actually read the indictment to you first. Then we're going to pass out what we call the preliminary jury instructions to you, and I'm going to read those to you. And then we expect to have opening statements. So that's what we're going to do this morning. We previously swore you in as jurors, so we're ready to start with the reading of the indictment. So Sarah Lynn, if you please read the indictment.
In the Superior Court of the State of Arizona and for the County of Maricopa, the State of Arizona versus Bryan Wayne Hulsey. Indictment. Count 1, first-degree murder. Count 2, attempted first-degree murder. Grand jurors of Maricopa County, Arizona, accused Bryan Wayne Hulsey on this 28th day of February 2007, charging that in Maricopa County, Arizona, count 1, Bryan Wayne Hulsey on or about the 19th day of February 2007, intending or knowing that his conduct would cause death to a law enforcement officer, caused the death of Anthony Hawley, a law enforcement officer who was in the line of duty in violation of Arizona law. Count 2, Bryan Wayne Hulsey on or about the 19th day of February 2007, intending or knowing that his conduct would cause death to a law enforcement officer, attempted to cause the death of David Poitia, a law enforcement officer who was in the line of duty in violation of Arizona law. A true bill dated February 28, 2007, signed Andrew P. Thomas, Maricopa County Attorney, by Juan Martinez, Deputy County Attorney, and by the foreperson of the grand jury, to which charges the defendant pleads not guilty.
Thank you. Okay, Kim's on her way over with the jury instructions, so she's going to pass those out. I'll wait for you to get them before I start reading. Okay. Before we start, I want to make sure, juror number 4, I think you have the listening device. Is it working for you?
Yes, it is.
Okay, thank you. All right, ladies and gentlemen, these are the preliminary jury instructions. Duty of jurors. Ladies and gentlemen, Now that you've been sworn, I will briefly tell you something about your duties as jurors and give you some instructions. At the end of the trial, we'll give you more detailed instructions, and those instructions will control your deliberations. It will be your duty to decide the facts. You must decide the facts only from the evidence produced in court. You must not speculate or guess about any fact. You must not be influenced by sympathy or prejudice. You will hear the evidence, decide the facts, and then apply the law I will give you to those facts. That is how you will reach your verdict. In doing so, you must follow that law whether you agree with it or not. You must not take anything I may say or do during the trial as indicating any opinion about the facts. You and you alone are the judges of the facts. Importance of jury service. Jury service is an important part of our system of justice with a long and distinguished tradition in American law. From the beginning, American law has viewed the jury system as an effective means of drawing on the collective wisdom, experience, and fact-finding abilities of persons such as yourselves. While it may be an occasional inconvenience or worse, jury service is an important responsibility for you, one which I'm sure you will take seriously. Presumption of innocence. The state has charged the defendant with certain crimes. The charges are not evidence against the defendant. You must not think the defendant is guilty just because the defendant has been charged with certain crimes. The defendant has pled not guilty. The defendant's plea of not guilty means that the state must prove each element of each charge beyond a reasonable doubt. The law does not require a defendant to prove innocence. Every defendant is presumed by law to be innocent. Burden of proof. The state has the burden of proving the defendant guilty beyond a reasonable doubt. In civil cases, it is only necessary to prove that a fact is more likely true than not, or that its truth is highly probable. In criminal cases such as this, the state's proof must be more powerful than that. It must be beyond a reasonable doubt. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty, and in criminal cases the law does not require proof that overcomes every doubt. If, based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find the defendant guilty. If, on the other hand, you think there is a real possibility that the defendant is not guilty, you must give the defendant the benefit of the doubt and find the defendant not guilty. In deciding whether the defendant is guilty or not guilty, do not consider the possible punishment. Constitutional right not to testify. A defendant in a criminal case has a constitutional right to not testify at trial, and the exercise of that right cannot be considered by the jury in determining whether a defendant is guilty or not guilty. Evidence. You will decide what the facts are from the evidence presented here in court. That evidence will consist of testimony of witnesses, any documents and other things received into evidence as exhibits, and any evidence stipulated to by the parties or that you are instructed to consider. You will decide the credibility of the witnesses and wait to be given to any evidence presented in the case, whether it is direct evidence or circumstantial evidence. Direct and circumstantial evidence. Evidence may be direct or circumstantial. Direct evidence is a physical exhibit or the testimony of a witness who saw, heard, touched, smelled, or otherwise actually perceived an event. Circumstantial evidence is the proof of a fact or facts from which the existence of another fact may be determined. The law makes no distinction between direct and circumstantial evidence. You must determine the weight to be given to all the evidence without regard to whether it is direct or circumstantial. Stipulations. During the trial, the lawyers are permitted to stipulate that certain evidence exists. This means both sides agree that evidence exists and is to be considered by you during your deliberations at the conclusion of the trial. You are to treat a stipulation as any other evidence. You are free to accept it or reject it, in whole or in part, just as any other evidence. Bench conferences and recesses. From time to time during the trial, it may become necessary for me to talk with the attorneys out of the hearing of the jury, either by having a conference at the bench when the jury is present in the courtroom or by calling a recess. Please understand that while you are waiting, we are working. The purpose of these conferences is not to keep relevant information from you, but to decide how certain evidence is to be treated under the rules of evidence and to avoid confusion and error. We will, of course, do what we can to keep the number and length of these conferences to a minimum. I may not always grant an attorney's request for a conference. Do not consider my granting or denying a request for a conference as any indication of my opinion of the case or of what your verdict should be. Please do not be concerned with what we are discussing at any bench conference we may have. Please respect the privacy of those participating in the bench conference in order to maintain the fairness of the trial. Rulings of the court. Admission of evidence in court is governed by rules of law. I will apply those rules and resolve any issues that arise during the trial concerning the admission of evidence. If an objection to a question is sustained, you must disregard the question and you must not guess what the answer to the question might have been. If an exhibit is offered into evidence and an objection to it is sustained, you must not consider that exhibit as evidence. If testimony is ordered stricken from the record, you must not consider that testimony for any purpose. Do not concern yourselves with the reasons for my rulings on the admission of evidence. Do not regard those rulings as any indication for me of the credibility of the witnesses or the weight you should give to any evidence that has been admitted. Credibility of witnesses. In deciding the facts of this case, you should consider what testimony to accept and what to reject. You may accept everything a witness says, or part of it, or none of it. In evaluating testimony, you should use the test for accuracy and truthfulness that people use in determining matters of importance in everyday life, including such factors as the witness's ability to see or hear or know the things the witness testified to, the quality of the witness's memory, the witness's manner while testifying, whether the witness has any motive, bias, or prejudice, whether the witness is contradicted by anything the witness said or wrote before trial or by other evidence, and the reasonableness of the witness's testimony when considered in the light of the other evidence. Consider all of the evidence in light of reason, common sense, and experience. Testimony of law enforcement officers. The testimony of a law enforcement officer is not entitled to any greater or lesser importance or believability merely because of the fact that the witness is a law enforcement officer. You are to consider the testimony of a police officer just as you would the testimony of any other witness. Expert witness. A witness qualified as an expert by education or experience may state opinions on matters in that witness's field of expertise and may also state reasons for those opinions. Expert testimony should be judged just as any other testimony. You are not bound by it. You may accept it or reject it in whole or in part, and you should give it as much credibility and weight as you think it deserves, considering the witness's qualifications and experience, the reasons given for the opinions, and all the other evidence in the case. Evidence, statements of lawyers, and rulings. As I mentioned earlier, it is your job to decide from the evidence what the facts are. Here are 6 rules on what is and what is not evidence. Number 1, evidence to be considered. You must determine the facts only from the testimony of witnesses and from exhibits admitted in evidence. Anything you may see or hear when the court is not in session, even if what you see or hear is done or said by one of the parties or by one of the witnesses, is not evidence and must not be considered by you. If you should hear or see anything pertaining to the case outside the courtroom, or if anyone should attempt to speak to you about this case outside the courtroom, please report to me as soon as you can. Number 2, lawyer statements. Statements or arguments made by the lawyers in the case are not evidence. Their purpose is to help you understand the evidence and law. Number 3, questions to a witness. A question is not evidence. A question can only be used to give meaning to a witness's answer. 4, objections to questions. If a lawyer objects to a question and I do not allow the witness to answer, you must not try to guess what the answer might have been. You must also not try to guess the reason why the lawyer objected in the first place. Number 5, rejected evidence. At times during the trial, evidence may be offered that I do not admit as evidence. When evidence is not admitted, you must not consider it for any purpose. 6, stricken evidence. At times I may order some evidence to be stricken from the record. Then it is no longer evidence and you must not consider it for any purpose. Jury not to consider penalty. You must decide whether the defendant is guilty or not guilty by determining what the facts in the case are and applying these jury instructions. You must not consider the possible punishment when deciding whether your verdict is guilty or not guilty. Separate counts. Each count charges a separate and distinct offense. You must decide on each count separately on the evidence with the law applicable to it, uninfluenced by your decision on any other count. You may find that the state has proven beyond a reasonable doubt some prove beyond a reasonable doubt all, some, or none of the charged offenses. Your finding for each count must be stated in a separate verdict. The charged offenses. To assist you in considering the evidence that will be presented during the trial, I will now tell you about the crimes with which the defendant is charged. The defendant is charged in count 1 with first-degree murder of Anthony Holly, and in count 2 with attempted first-degree murder of David Goydia. Count 1, first-degree murder. As charged in count 1, the crime of first-degree murder requires proof of the following. Number 1, the defendant engaged in conduct intending or knowing that the conduct would cause the death of another person who the defendant knows is a law enforcement officer, and 2, the law enforcement officer was in the line of duty, and 3, the defendant caused the death of the law enforcement officer. Count 2, attempted first-degree murder. As charged in count 2, the crime of attempted first-degree murder requires proof of the following. 1, the defendant attempted to cause the death of a person, and count 2, the defendant engaged in conduct intending or knowing that the conduct would cause the death of another person who the defendant knows is a law enforcement officer, and 3, the law enforcement officer was in the line of duty. The defendant has pled not guilty to these charges. The state must prove each element of the charged crime beyond a reasonable doubt. I will give you more details and definitions about the alleged crimes in the final jury instruction. Juror note-taking. At the end of the trial, you will have to make your decision based on what you recall of the evidence. You should pay close attention to the testimony as it is given. You have been provided with notepads and pens. The court encourages you to take notes during the trial if you wish to do so. Do not let note-taking distract you so that you miss hearing or seeing other testimony. You may use your notes during your deliberations at the end of the trial. Until then, keep your notes to yourself. During recesses in the trial, you may leave your notes on your seat. Your notes are confidential and my bailiff will guard them. No one will be allowed to read your notes. Whether you take notes or not, you should rely upon your own memory of what was said and not be overly influenced by the notes of other jurors. After you've rendered your verdict, the bailiff will collect your notes and destroy them. Do not be influenced at all by my taking notes at times. What I write down may have nothing to do with what you will be concerned with at this trial. Admonition. I'm not going to say a few words about your conduct as jurors. I'm going to give you some do's and don'ts, mostly don'ts, which I will call the admonition. Do wear your juror badge at all times in and around the courthouse so everyone will know you are on a jury. Each of you has gained knowledge and information from the experiences you have had prior to this trial. Once this trial has begun, you are to determine the facts of this case only from the evidence that is presented in this courtroom. Arizona law prohibits a juror from receiving evidence not properly admitted at trial. Therefore, do not do any research or make any investigation about the case on your own. Do not view or visit the locations where the events of the case took place. Do not consult any source, such as a newspaper, a dictionary, a reference manual, television, radio, or the internet for information. If you have a question or need additional information, submit your request in writing and I will discuss it with the attorneys. Do not talk to anyone about the case or about anyone who has anything to do with it, and do not let anyone talk to you about those matters until the trial is ended and you have been discharged as jurors. This prohibition about not discussing the case includes using email, Facebook, MySpace, Twitter, instant messaging, BlackBerry messaging, iPhones, iTouches, Google, Yahoo, or any internet search engine, or any other form of electronic communication for any purpose whatsoever, if it relates in any way to this case. This includes, but is not limited to, blogging about the case or your experience as a juror on this case, discussing the evidence, the lawyers, the parties, the court, your deliberations, your reactions to testimony or exhibits, or any aspect of the case, or your courtroom experience with anyone whatsoever until the trial is ended and you have been discharged as jurors. Until then, you may tell people you are on a jury and you may tell them the estimated schedule for the trial, but do not tell them anything else except to say that you cannot talk about the trial until it is over. One reason for these prohibitions is because the trial process works by each side knowing exactly what evidence is being considered by you and what law you are applying to the facts that you find. As I previously told you, Submit your request in writing, and I will discuss it with the attorneys. During the trial, you are not to engage in any conduct that impairs or interferes with your ability to hear and understand the court proceedings. Do not form final opinions about any fact or about the outcome of the case until you have heard and considered all of the evidence, the closing arguments, and the rest of the instructions I will give you on the law. Keep an open mind during the trial. Form your final opinions only after you've had an opportunity to discuss the case with each other in the jury room at the end of the trial. Please advise me in writing immediately if you believe that any juror has violated any provision of this admonition. Before each recess, I will not repeat the entire admonition I've just given you, thankfully. I will probably refer to it by saying, please remember the admonition, or something like that. However, even if I forget to make any reference to it, remember that the admonition still applies at all times during the trial. Exclusion of witnesses. The rule of exclusion of witnesses is in effect and will be observed by all witnesses until the trial is over and a result is announced. This means that all witnesses will remain outside the courtroom during the entire trial except when one is called to the witness stand. They will wait in the areas directed by the bailiff unless other arrangements have been made with the attorney who has called them. The rule also forbids witnesses from telling anyone but the lawyers what they will testify about or what they have testified to. If witnesses do talk to the lawyers about their testimony, other witnesses and jurors should avoid being present or overhearing. The lawyers are directed to inform all their witnesses of these rules and to remind them of their obligations from time to time as may be necessary. The parties and their lawyers should keep a careful lookout to prevent any potential witness from remaining in the courtroom if they accidentally enter. Questions by jurors. If at any time during the trial you have difficulty hearing or seeing something that you should be hearing or seeing, or if you get into personal distress for any reason, raise your hand and let me know. If you have any questions about parking, restaurants, or other matters relating to jury service, feel free to ask one of the court staff. But remember that the admonition applies to court staff as it does to everyone else, so do not try to discuss the case with court staff. If you have a question about the case for a witness or for me, write it down, but do not sign it. Hand the question to the bailiff. If your question is for a witness who is about to leave the witness stand, please signal the bailiff or me before the witness leaves the stand. The lawyers and I will discuss the question. The rules of evidence or other rules of law may prevent some questions from being asked. If the rules permit the question and the answer is available, an answer will be given at the earliest opportunity. When we do not ask a question, it is no reflection on the person submitting it. You should attach no significance to the decision not to ask a question. I will apply the same legal standards to your questions as I do the questions asked by the lawyers. If a particular question is not asked, please do not guess why or what the answer might have been. Media coverage. There may or may not be news media coverage of the trial. What the news media covers is up to them. If there is media coverage, you must avoid it during the trial. If you do encounter something about this case in the news media during the trial, end your exposure to it immediately and report it to me as soon as you can. If there are cameras in the courtroom during the trial, do not be concerned about them. Court rules require that the proceedings be photographed or televised in such a way that no jury, and that should read no juror, can be recognized. Scheduling during trial. The trial is expected to last through August 28, 2014. We will all do our best to move the case along, but delays frequently occur. These won't be anyone's fault, so do not hold them against the parties. Delays usually occur because the attorneys and I often need to resolve certain legal matters before these matters may be presented to you in court, or because I am busy with matters in other cases. The usual hours of trial will be from 10:30 to 4:30. We'll take short recesses about every mid-morning. That's not correct. We won't take a mid-morning recess. We'll go from 10:30 till noon. And mid-afternoon, we will take a recess, and occasionally stretch breaks in place. That probably won't happen either. We will recess at noon and begin again at 1:30. Unless a different starting time is announced prior to recessing for the evening, you may assume a starting time of 10:30 for the next day. At the beginning of the day, please assemble in the jury room for this division. Please do not come back into the courtroom until you are called by the bailiff. Order of trial. Guilty, not guilty phase. Criminal trials generally proceed in the following order. First, the prosecuting attorney will make an opening statement giving a preview of the case. The defendant's attorney may make an opening statement outlining the defense case immediately after the prosecutor's statement, or it may be postponed until after the state's case has been presented. What is said in opening statements is not evidence, nor is it an argument. The purpose of an opening statement is to help you prepare for anticipated evidence. Second, the state will present its evidence. After the state finishes the presentation of its evidence, the defendant may present evidence. The defendant is under no obligation to present any evidence. However, if the defendant does produce evidence, the state may present additional or rebuttal evidence. With each witness, there is a direct examination, a cross-examination by the opposing side, and finally, redirect examination. This usually ends the testimony of that witness. Third, after all the evidence is in, I will read and give you copies of the final instructions, the rules of law you must follow in reaching your verdict. Fourth, the attorneys will make closing arguments to you to tell you what they think the evidence shows and how they think you should decide the case. Just as in opening statements, what is said in closing arguments is not evidence. Fifth, you will deliberate in the jury room about the evidence and rules of law in an effort to reach the verdict. If you unanimously agree upon the verdict, it will be read in court with you and the parties present. Alternate jurors. The law provides for a jury of 12 persons in a case such as this. We have more than 12 jurors so that if a juror becomes ill or has a personal emergency, the trial can continue without that juror. At the end of the case, alternate jurors will be determined by lot in a drawing held in open court. Please do not be concerned with who may or may not be chosen as an alternate at the end of the case. Conclusion to preliminary instructions. The rules of law I have charged you with in the past few minutes are preliminary only. At the end of the case, I will read to you and give you a copy of the final instructions of law. In deciding the case, you must be guided by the final instruction. Okay. Let me have you look quickly at page 10 because I left out a word and I wanted to make it clear that that word is supposed to be there. At the top of page 10, number 2, where it says the law enforcement officer was in the line of duty, the word "and" should follow that, A-N-D. I read that to you, but I did not write it in the instructions, and I wanted to make sure that that was clear. So again, at the top of page 10, number 2, the law enforcement officer was in the line of duty, and number 3, the defendant caused the death of the law enforcement officer. Before we start opening statements, let me talk to you a little bit about questions from jurors, because it's a process if you have a question. If you have a question, you have separate forms in your books to write that question down. After each witness testifies, I'm going to look to the jury to see if you have any questions for that witness. And if you do, just raise your hand. Kim will come and get it. I'll talk it over with the lawyers because I need to analyze whether we can ask that question. And again, as I told you in the instructions, don't be offended if I can't ask your question. There may be legal reasons for that. So don't raise your hand during testimony or don't speak the question. That's how we do it. Okay? All right. So we're ready now for opening statements. The state gets to go first. Mr. Martinez, on behalf of the state.
I've got something for you. Or I've got this.